Well, all right, everyone. Let's get started with our second panel, where we'll address some of the developments at the legislature, the headwinds that we faced, and some successes as well. You know, the legislature approved measures this session to repair holes in the state's Public Information Act. And we also learned a lot about the state of open government in Texas, and especially in the wake of the shooting at Robb Elementary in Uvalde. So we've got a lot that was revealed post efforts to get more transparency. It wasn't easy. Also, the Texas Citizen Participation Act, the state's anti-SLAPP statute, again, found itself in the mix this session, again, facing headwinds, attempts to strip these vital protections. Were once again at the fore from powerful chairmen, but a broad coalition got together, much like with the TPIA, and sought to preserve these meaningful protections for speakers and speech. We have a lot to cover. My name is Arif Panju with the Institute for Justice, and I have the privilege of serving on the board of the FOIFT and being a past president. And I'm looking forward to moderating this panel, so let's start with some introductions. First, joining us on the screen is Representative Joe Moody, who represents District 78, which covers much of northern El Paso. He is Speaker pro tempore at the Texas House of Representatives, a position he's held under 3 different speakers. He's also twice chaired important standing legislative committees in the House, is the founder and co-chair of the Bipartisan Criminal Justice Reform Caucus. And he also, Representative Moody also vice-chaired the House Investigative Committee sent to Uvalde in the wake of the Robb Elementary shooting there in 2022. Outside of the legislature, he's an attorney that works as a senior counsel at El Paso-based West Star Bank. He's a former district attorney, but also a former criminal defense attorney, which warms my heart. So thank you for joining us. Let's save our applause for the end. Next, we have Emily French. Emily French is a policy director at Common Cause Texas, where she works to expand voting rights, campaign finance reform, accountability, and transparency in Texas government. She is a graduate of the University of Texas School of Law. In 2018, she spent 5 years after law school at the Texas Civil Rights Project doing public interest work, and which is profoundly important. Next, we have Rachel Clow, is a specialty producer at KRIS 6 News, leading collaborative investigative reporting in South Texas. She previously spent 15 years at the Corpus Christi Caller-Times. Her team's work has exposed a lot, including corruption. It's prompted safety improvements, and she's earned multiple awards, including 2 Carol Nealon Awards from the Texas Association of Broadcasters. She now serves on the Legislative Affairs Committee of TAB. She's a graduate of Rochester Institute of Technology with a degree in photojournalism, and from Texas A&M Corpus Christi with a master's in business administration. And last but not least, J.T. Morris, who joined the Foundation for Individual Rights and Expression, litigates constitutional cases and specializes in First Amendment litigation at all levels, trial, appellate, and supreme. And after running his own law firm, litigating similar issues, including anti-SLAPP and digital media issues as well, he's brought the heat to fire, which is great to see. He's testified before the legislature on anti-SLAPP issues and advised organizations and officials on legislation affecting free speech and free press. His commentary on constitutional issues and the First Amendment and open government have appeared in several media outlets. He's a graduate of Vanderbilt University, where he studied computer science and economics, and a graduate of William and Mary Law School. So let's jump right in. I'll start with Representative Moody. Public trust in government and transparency are intertwined. You have worked closely in closing the dead suspect loophole, something that many people here are familiar with. But how did the mishandling of public information in the immediate aftermath of the shooting at Robb Elementary affect public trust? And if you could, how has the dead suspect loophole played into cases like these?
Arif, thank you. I appreciate the question, and it's good to join you all. Sorry to have to be doing it from Mountain Time, but I spent plenty of time in Austin this year, so time to be home for a bit, if you don't mind. So I appreciate the technology. Look, I don't know that there's a case that crystallized for general membership in the House the problem with the dead suspect loophole, more so than the tragedy in Uvalde. Obviously, there were other cases prior to that. We started working on it several sessions ago to close that out. But unless you heard the testimony from those families who had a loved one die in custody or something to that effect, unless you heard that testimony, you didn't really have a good line of sight into what it meant. But that tragedy is one that I think allowed everybody to know how much could be withheld from the public eye, particularly in a situation. I'll go back to your question is, the part of the report that we produced during our investigation into the Robb Elementary School shooting was focused on the information flow. How did information flow? Right? You had a governor acting as a PI opening days of that, which is completely bizarre. And you had bad information. You had bad information coming out not once, not twice, multiple times in the days after, and that goes against protocol. Everybody knows in those situations the initial information it typically is going to change and could change drastically, and so you try to give only concrete things in those opening stages, but they didn't do that then. And I think the report, while very much focused on the shooter, the safety of the school, the law enforcement failings that day, also looked at how information was handled. Because by the time we got there for our investigation, public trust in that community for anyone speaking from a place of authority was zero. I don't know that I've ever been faced with a more difficult job, because our job was not just to lay the facts bare, but try to figure out a way to reestablish some level of trust with a community who was devastated. And the only way that we could think to get them back to a path to potentially heal going forward is they needed some stability. They needed solid ground to stand on. They needed to know what happened to their kids, what happened in that school that day. And the handling of information at the front end of that tragedy was certainly not the way it should have been done, in my opinion. And after the fact, we've seen documents continue to be held back and held back and held back and held back, and a lengthy court battle over those documents. Look, it's not pretty. I've seen everything that DPS would provide to us in the investigation. A lot of the reason that we were able to get everything is because we did all of our meetings in executive session. That's always been my conversation, is the reason we were able to give, and Don McLaughlin, the mayor at the time and now state representative, said it was the most thorough report that he's seen to date. And why? It's because we had the information. That's the key. And so it's extremely ugly what happened there. It's devastating to go through those records and understand it. But the public, in cases like that, the public needs to know more rather than less, because that's what creates a trust foundation. If we do believe, and I heard a lot of conservatives say, like, we are the government, we control the government, then those are our records. They belong to us. And we don't, unless we have really good reason, we're not keeping those things from the public eye. And so, as challenging as that is, and as difficult as that is, that's the promise that we have to keep. And it is most certainly under attack.
Do you feel that the dead suspect loophole helped? Do you think that helped shield, or do you think the fix, if it wasn't in place, would have made it worse?
Well, the fix certainly is going to help on the back end of this. Obviously, there's an ongoing investigation and prosecution into some law enforcement officers. So they were in the inception of their of the legal claim. I think the governmental entities were claiming the ongoing investigation exception. So something that we haven't touched, and it's a long time. And I think one of those that does make some sense. Other entities have waived that in that investigation, but some haven't. And so, but we knew once that would end, if we hadn't closed the dead suspects loophole, because the shooter in this case was killed on site, those records theoretically could be shielded from the public forever. And I think that was a staggering thing for people to hear. Before we closed it in 2023, in the wake of the shooting. I don't think people understood the gravity of that. But that, unfortunately, that tragedy really crystallized why it was important to close that loophole, because we would never know. And the things that I saw behind closed doors, the public would never see. And that's in a tragedy like that, where we had a government failing on multiple fronts. As we said, there are multiple systemic failures, and the public could be kept from that information. No, that's not acceptable. So I'm grateful that we were able to pass the law finally to get there. It took us 3 sessions, which seems a little like a little too much work to do to shine light on very tragic situations. But that's the work that's worth doing.
Thank you, Representative Moody. Rachel, I'd like to turn to you. One bright spot this session was addressing the government's failure to respond to public information requests. You'd think with a statute where the default setting is information is public, and there's an exception that the government would have to respond, but that's not always the case. So can you set the stage for us about what it looks like in the real world, why this problem needed correcting? And if you could, also share your thoughts on how the legislature addressed this issue from your standpoint.
Certainly. Required response is about common sense. Information is public. If I put in a public information request, or a member of the public puts in a request, at a minimum, the governmental body should say, we have the records, we don't have the records, or we're withholding them based on this previous exemption, right? But they didn't have to do that. So what I found is, as a journalist, very often they would respond to me because they would know I'm going to write a story if you don't respond to me. What I found is many members of the public who would make requests were simply being ignored. In the city of Taft, we did an investigation into the city secretary, and we learned that she was being paid excessive amounts of overtime while she was at her children's sporting events. Live streaming from sporting events, we had time cards. So then we began digging further. Citizens began putting in records requests. She was arrested and charged with 4 felonies. She remained in charge of responding to public information requests and just stopped responding. So members of the public couldn't get any information. We had to find sources to get us information. We finally got information, and the finance director for the city was arrested on 8 felonies. But again, there was no requirement that they respond to people whether they had the information or didn't, which is why this law is so important. As a journalist, very often I will only receive a partial response to what I request. If the governmental body doesn't know that I have the information, they're not going to respond fully. So by now having a requirement that they say they have the information or not, when they don't respond, we can now say they lied because we have the information. And that is one of the positive parts of this change. Additionally, if they wait 10 days and they haven't responded, I can ask the Attorney General to not have these records, not allow them to charge me for these records. And they will have to have mandatory training. So those are all incredible positives.
It's great when there's teeth baked into a statute that requires transparency, and when they start clamping down on recalcitrant government officials. It's not hard to comply with an open records request. It takes some creativity not to sometimes. Let me bring in Emily into the conversation. You spent some time in the legislature this session. You were in the trenches. Can you tell us about some of the legislative successes and attempts to get some reforms through as well during the session that completed earlier this year, and including any thoughts you have on HB 4219, the required response legislation that got to the governor's desk?
Yeah, and I hope I don't lose the room when I say this, but I have been on both sides of Public Information Act requests. I'm so sorry. I think I did a good job. It's fine. But I remember when I was at a law firm briefly where I was processing requests for government entities. And I remember the first thing I did when I got my first, stack of documents to redact and review for relevance, the first thing I did was call my mom, who's a public school teacher, and go, "Mom, I'm so serious. Please do not email anything you wouldn't want in the newspaper. Please, I am not joking about this." And the second thing I did was go to a colleague and go, "Hey, what am I supposed to do with this? How do I, help me along? This is my first time. I want to do a good job." And I think that it is so important to have a standard across everyone who is doing Public Information Act requests for turning these things over, that we're all doing the same good job. And I remember, when I got my first batch of discovery for a lawsuit at this law firm, it was very different from when I got this Public Information Act request, because there are so many more penalties, teeth, et cetera, involved in discovery. And that's not the fault of the law firm. It's a great law firm, but at the legal level, at the legislative level, we have to make sure that these teeth, these things are in law. So that's what I think is so great about 4219. There are a couple other great bills as well. 4214, and I'm sorry, they're all the numbers, and I've been in redistricting mode, so you all kind of look like little districts to me right now, but I'll do my best to get back into this mode. But requiring the Attorney General's office to maintain a publicly accessible database listing government's current public information request addresses. Great bill. I think it's great to make it easier to ask for records. In this room, it's a little bit more difficult because y'all know how to ask for records, right? Like, this is a group of folks who's familiar with the people they're asking for records from. But in terms of the general public, it's great to have that list of addresses. And a couple of bills, 3711 and 1522 HBs, both requiring more public information for open meetings, things like that, open meetings violations. I think those are some great successes. There were a couple of things that I wish had passed. One, 4991, I believe, would have required open government training for outside attorneys hired by governments to handle Public Information Act requests. So that would have, given me a training if we could time travel. And I'm hoping to see some more things like that. I think that, I always like a little teeth. I'm very sympathetic to local governments. It's very difficult, but, lots of things coming through. But I definitely think, a couple more teeth next session we'll be hoping for.
That's great. JT, let me ask you. You were also in the trenches this session, and once more, it involved the anti-SLAPP law, the Texas Citizen Participation Act, which allows individuals who engage in expressive activity to get meritless lawsuits dismissed, lawsuits just designed to silence them. Can you tell us about the efforts this session to change and weaken, in my view, Texas' anti-SLAPP legislation? And what do you think, if you could address this as well, what do you think changed the tide and persuaded the legislature to stay away from changing the law?
Yeah, sure. Thanks for the question, Arif. So as Arif said, right, the TCPA, it's a law that allows Texas citizens who speak out on matters of public concern to protect themselves when they're sued by speaking out on matters of public concern. And we see that a lot, right? I mean, you see business owners suing Texans because they might write a critical review online. You see local officials, state level officials suing their critics. You see environmental groups getting sued by businesses because they're out there, voicing their opinions on public issues. And so what the TCPA does is it gives, citizens who are sued for speaking out and exercising their First Amendment freedoms an opportunity to get early dismissal of a case. You can go to a trial court when you're sued, say, look, this person is suing me not because their case has merit, but they're trying to silence me. And unless the person suing you is able to put on evidence that they actually have a legitimate case, your case gets dismissed and you win your attorney's fees, which is a really good thing. We don't want people dragged through the court system for doing what the First Amendment guarantees them that they can do. And so the past couple sessions, we've had a number of attempts to, as Arif noted, weaken the TCPA and some of its key protections. There's really three key things that the TCPA does. One is that early dismissal mechanism. Two, again, if you win, the other side has to pay your attorney's fees, and the judge doesn't have any discretion. They have to, which is really good for two reasons. One, it deters would-be slap filers from suing people, trying to silence them. And if they go ahead and do it anyway, you're made whole for defending your First Amendment rights from a frivolous lawsuit. The third thing the TCPA does is, let's say the trial court gets it wrong, refuses to dismiss your case. What the TCPA says is you can take an appeal, and you only have to focus on your appeal. You don't have to litigate in the trial court too, which is really good. We don't want people trying to defend their First Amendment rights litigating in two courts at once, running up their attorney's fees, and then they're basically faced with the choice of, do I expend the time, the money, the emotional effort litigating in two courts, or do I just give in and self-censor? That's not a result we want, certainly not a result the First Amendment really wants either. So this past session, we had two bills, one trying to remove the mandatory attorney's fees shifting provision, and two, another one was trying to remove that automatic stay, so it would force litigants to defend their First Amendment rights in two courts at the same time. Both fairly bad things. We didn't really understand, the folks who were fighting against this bill, where this was all coming from. Usually you would hope that when lawmakers propose a bill, they're trying to solve a problem. Consistently, we've asked, what's the problem here? We get, a one-off case here or there, but really not data, really not any examples showing that this was removing the fee shifting and removing the automatic stay was necessary. So we kind of dug around, had our own data, published that data showing, look, trial courts get these wrong all the time. You need to make sure that the trial court proceedings are stayed when people defending their First Amendment rights are appealing the trial court's mistakes. We had a lot of examples. We had folks who the TCPA has benefited write op-eds, testify about their experiences and about how they faced, but for the TCPA, they would have no choice but to shut up because they couldn't afford to fight in court if they weren't guaranteed their attorney's fees at the end. So I think, ultimately, Arif, as always, the anecdotes, the examples, the data was on our side. And really, I think having those people tell their stories about how, but for the TCPA, they couldn't have exercised their First Amendment rights, really swayed, I think, the lawmakers who were hearing these bills and caused them to table it and not even get them out of committee.
Great. That's great, because in prior sessions, it seemed like there was more momentum pushing for that change. And did you notice maybe a loss of momentum from the side of folks that were again giving in another attempt to try to water it down?
Yeah, I think this term, the momentum early was pretty strong. We were all really concerned that this was going to be the session that they might get one of these through, especially removing the automatic stay, which would have forced people again to defend their First Amendment rights in two courts at once. But I think, again, having those stories really showing in practice, right, how that automatic stay helps people defend their First Amendment rights and make sure that these frivolous lawsuits don't silence people who are speaking out on an important issue, whether you're a journalist or just a citizen commenting on politics or business. That really helped turn the tide and get that momentum swinging back towards leaving the TCPA in place.
Representative Moody, let me bring you back in here. And I have, you have a different perspective as someone that is a member of the chamber. You've seen fights at the ebb and flow of that chamber, especially in the context of the Public Information Act in particular. And could you comment on the overall mood at the moment in the House and the Capitol in general vis-a-vis transparency laws and open government? And if you could also touch upon what you've seen being effective at kind of protecting the TPIA or perhaps reforming it, which seems like sometimes there's a lot of headwinds on that front as well.
Yeah, and it's difficult because philosophically, when you hear from folks, right, we want transparency, we want openness, we want to know what's going on, right? No one disagrees with those principles. Secrecy is not something that anybody stands up at the front mic or the back mic and defends. This needs to be secret, right? but it almost always depends on who's asking, right? Who do we, you know, who do we offer those protections to, and why? I feel like we end up like all things nowadays, everything's viewed through this kind of hyper political lens, hyper partisan lens. How do you posture in any policy area to make something more political, more partisan, right? So when we talk about law enforcement records, oh, well, if you don't agree with us, you hate law enforcement. You want to defund the police, you want to do this, you want to do that. Well, no, if we drill down into it, nobody that I can tell in terms of people that I work with on both sides of the aisle won't want to tear down people that are serving our community in a, in an honest and fair fashion. I think that everybody will tell you and is that they want a level of accountability when something bad happens. And you don't have that unless you have some avenue to find that out. We saw that come up in the regular session and then in the successive special sessions, with dealing with these new department files. And I think generally everybody can say, okay, you have an unsubstantiated claim. All right, do we need to, have an, do you need to have unwarranted harassment of officers? No, nobody agrees with that. But because the way that was written and we didn't have clarity about what could or couldn't go in there, that's the problem. That's the problem. And when you sit with people on the law enforcement side and they say, oh, no, body cam, that doesn't go in there, and dash cam, that doesn't go in, they're governed somewhere else. These reports, they're governed somewhere else. And no, this is different. It doesn't include any of that stuff that you're talking about. And I go, okay, well, then just say it. Just put it in there. Put the verbiage in there. If it's not going in there anyway, then the verbiage is essentially nothing, right? Because you're telling me it doesn't go in there. So just put it in there. And if I'm right and it could accidentally get in there, then we've protected that. And if you're right, the language means nothing. And so when you put that on the table and they go, no, I don't want to put that on paper. And you go, well, okay, now my antenna's up. Okay, well, why? Why if the intent is for those things not to be there, then why not just say it? Let's say what we mean. And so I think that's, it created a lot of consternation. And in that particular policy instance, you had a bipartisan group of folks that were saying, we don't have clarity about this. And we're okay with shielding records on unsubstantiated claims. I think there's a question about who substantiates them. That's a whole nother conversation we could have. But you could get to a point of agreement that, we're not looking to drag people through the mud that haven't done anything wrong. That's not the point. But that's the posture people will take. And if you don't agree with them lock stock, then you're anti-law enforcement. You hate cops. Rank and file police officers are working class folks. They're working people. They're part of working families. They do an extremely difficult job. I have for sessions worked to make sure that those rank and file working class folks are protected when they're injured on the job, that they have protections from their employers. I've done an enormous amount of work to make sure that they're taken care of because they're doing a hard job for us. But at the same time, because it's a high calling and it's a very difficult job, it's a very important job, then there's also a higher level of accountability. And that's okay too. We can do both things at once. We can take care of our officers and respect the job they're doing, but also demand a high level of professionalism. That job demands that, and that's okay. I don't know that I have a solution to get people out of a hyper-partisan, hyper-political environment. I think we should always focus on policy first. One of my mentors in this business, Garnett Coleman from Houston, always told me, and I don't know if he borrowed it from someone else, but he said, good policy makes good politics. He said, don't flip them around. If you're chasing politics before policy, you're going to end up in a wrong position. But if you chase good policy, you will always have good politics. And so that's what we need to get back to. I don't know that one member from El Paso and others that are trying to figure that out can turn the tide of that. We just seem to be in a very hyper-partisan and hyper-political time in our country. But that's what we need to keep laser focused on. What is good policy for the public? And ultimately that will make the good politics.
Thank you. Rachel, you talked about teeth, and I think we can all agree that the Public Information Act needs stronger teeth. What kind of teeth? Like, what would be nice to have? I mean, what you have an experience, I think, where you got a really candid conversation with the Public Information Officer. And why don't you share us a little bit about that? Because I think it's important that it's not just us that think there are no teeth, but if the government thinks there are no teeth, then we got a problem.
You're 100% correct. So I live in essentially what's a small town, right? Corpus Christi, it's a city, but it's a small town. So I often run into public officials at the supermarket. I was preparing to come up to Austin to testify for required response and had a conversation with the Public Information Officer for San Patricio County. There is a resident in the county who puts in request after request after request, and she had no response from this public information officer for 8 months. So she began putting in requests with the AG for help. So I asked him about this when I ran into him at the supermarket, and he said, well, it's really easy. All I have to do when the AG sends me that notice is I just sign that I've already turned over everything. They don't even check. Required response, great, but there are so many other issues. There are governmental bodies and entities that want to be transparent, that want to give you the information, and I want to make that clear. There are several that we work with in South Texas that are great at responding. Required response does not fix it for those governmental entities that don't want to give you the information, right? They are going to wait until day 10 to tell you that you need to clarify. I had this happen last week. I was asked by the city of Corpus Christi to clarify a request, and they asked me to clarify it with the information I had already provided to them. Give us a date range. Give us a specific subject. Tell us specifically who you want these emails from. I responded, I said, I've already given you everything. And this is not resetting the clock. So then they sent me an estimate for $151, and I already have the documents, right? It's 3 emails. They want to charge me $151 for 3 emails. It's frustrating, and there is a lack of teeth, and we have to just keep pushing.
Emily, that lack of transparency, and I agree with Rachel that we do have to keep pushing. And part of pushing is going to the legislature. Mm-hmm. But there's perhaps a lack of transparency there as well. What about, can you tell us about how folks that want to get more involved in the legislative process might be stifled by really a lack of transparency kind of baked in? Can you address that for us? And let us know while you're doing that if you think coalitions are beneficial. And I know the Sunshine Coalition was important this session. Maybe you could touch on that as well.
Spoiler alert, I do think coalitions are beneficial, but I'll talk about that in a sec. JT mentioned bringing folks in to testify at the legislature, right? And I know that legislators often, bring someone in who's affected by a bill that's, up before a committee. And I have done a lot of testifying and trying to drive testimony, as I'm sure many of us have. The testimony process is always, it feels like you're trying to give people an orientation on something that you don't totally understand yourself, right? You say, you come in, you register, it's probably open an hour before, it might be open half an hour before. When you register, they might go, first come, first serve. They might go backwards, as one committee I testified in front of a lot started going backwards, like last person to testify first, or last person to register, first person to testify. The Texas Tribune did a great story this session about farmers who came in to testify against something regarding forever chemicals that was affecting like their livelihood. They went out and fed the cattle at 1:30 a.m. in Johnson County, drove to the Texas Legislature starting at 3 a.m. They got there and they were like, great, we'll do our 10:30 committee hearing and testify, and then we'll go home. And it was one of those endless days on the floor where they didn't get to testify until I think 1 a.m. the next day, nearly 24 hours from when they had woken up the night before. And it's one of those things where we have a lot of technology. You know, there could be a lot more transparency in that testimony process. I think, you know, like give us a cue, let us know what order you want to go in, set up a text alert system that's like, hey, you're next, so that, you know, hypothetically one doesn't have to run up the stairs and then testify out of breath and sound very silly on one's own video that one is watching back and thinking how silly one sounds, just hypothetically. But we have all this technology that I think we could use to make that testimony process more transparent and get more people involved. And I you know, would love to see some of that going forward. As far as coalitions go, this is my first session being part of the Sunshine Coalition. It has been so great. First of all, there's no better branding than Sunshine Coalition. Like, this just makes me happy to hear it. But also the makeup of the coalition is great. It's a lot of folks who work on different issues, sometimes different sides of different issues, but we all have like a need for transparency in common. And I think that improves all of our society, right? You know, sometimes it does feel like when you're requesting something from a county, it's me versus the county, but theoretically we all have the same goal of improving our institutions and improving public life in our county or state or, you know, nation. And I think it's great to work with the Sunshine Coalition folks and all get to work together on that. Plus, you know, it's nice to have more friends in the Capitol. Say hi, wave in the hallways is always good.
JT, similar question. The TCPA, several sessions, as you mentioned, have resulted in committee chairs even pushing bills to weaken the TCPA. And another good coalition, the Free Speech Coalition, is one that you're familiar with. And FIRE in particular does work national in scope as well. So can you tell us about that coalition, how it was effective, and whether having folks that are national in scope outside of Texas, like what dimension do they bring to a coalition in a state like Texas?
Yeah, I think with the TCPA, having the Free Speech Coalition, which we've had since 2019, when the legislature really took aim at gutting the bill, and over the past couple sessions when they've taken a smaller but just as concerning aim, has been vital. The Free Speech Coalition is made up of large media corporations, statewide organizations like Texas Association of Broadcasters, Texas Press Association, national legal organizations like the one I work for and like the Reef works for, Institute of Justice, small state level reporters, newsrooms, and a lot of other NGOs. I mean, and so when you have that, especially across sort of cross ideological bounds, I mean, you want to pick somebody out from a certain ideology, you'll find them in the Free Speech Coalition. I think really gave the coalition credibility, because we can then go to lawmakers and say, look, this isn't, to Representative Moody's point, this isn't a political thing, this is a policy thing, right? If you make these changes, you're not only hurting the folks maybe you're trying to dig at, you're going to hurt the folks on your side of the aisle too. And I think that's been pretty effective. Not only in Texas, but other states too, where we've seen state lawmakers take aim at protections for free speech and government transparency. So hopefully we don't have to assemble this coalition again, although history tends to repeat itself, but we'll see. And I do second Emily's call for the Capitol to figure out a better way to alert people that they can come testify. Nobody likes sitting in the Capitol Cafe for 8 hours a day watching the TV to see like when their time is up. But yeah, coalitions are a great thing. And I think when it comes to something like government transparency, something like First Amendment freedoms, where everybody, right, no matter what side of the political spectrum you might lie on, is effective, they can be particularly persuasive to lawmakers who may not understand the practical effects of what they're pushing.
Thank you. And you mentioned 2019, and I want to recognize and tip of the hat to Representative Moody, because 2019 was a huge deal, and there was a lot of leadership also with lawmakers to protect the TCPA. Representative Moody among them, right in the middle of it. And it led to a result that, it could have been a lot worse, and we were happy when we came out. And then having fended off with the coalition and folks that understand the importance of the statute, it's remained largely intact, which is great, even after 2019. I think now's the time that we're going to open it up for questions. And because we're recording, I will be repeating the question. So if you have me ask you to repeat it, that's why, so that everyone can hear and that it's in the recording. So I'm going to open up to the whole floor. Who has a question? I see a hand right in the back. No, that's you. Yes, stand up and let us know who you are and your question. It's a great question. Representative Moody, the question is to you and also to members of the panel if they want to jump in. And it relates to legislative transparency, the TPIA, and in particular, transparency about disclosing constituent emails and things that a lawmaker would receive. And is there a sense within the chamber that because we're dealing with the TPIA and the lawmakers control the statute, that maybe they're hesitant to open that up more robustly? What is the sense there as a lawmaker that you can opine on?
Yeah, I mean, I assume most offices have received public information requests. I know ours has. Typically, they're very much on a political bent, usually dealing with speaker politics, shockingly. I'm lucky that I have an attorney that works as my chief of staff and general counsel, so we work through those. I mean, ultimately, we try to, our goal in our office is to live what we expect other people to do. So even when we have exceptions we can raise, I don't know that we ever have. I remember disclosing a text message between me and the speaker at the time that probably wasn't going to be very helpful to anybody. But it was what I had, and it was a communication. It was responsive. I could have probably precluded it. There's some ways that I think we've actually changed a lot to shield an enormous amount of communication between legislators and their constituents. I understand some privacy matters related to constituents, and that's something that, like I said, if you're looking at policy, right, there's a reason that you want to encourage people to be open and transparent as they're having those communications with their legislators so they can help them, and they maybe not want that in the public sphere because they're going through a challenging time or something like that. But I've been through these redistricting lawsuits where you start to give an answer, under oath, and it involves a conversation with another legislator, and they go, "Whoa, wait a second, don't they haven't waived that privilege, so you can't say what that conversation was either." It's I would tend to think that most members probably want to keep their conversations between members confidential, or those with their staff. Obviously, I've got an attorney-client privilege with my general counsel, so it's a little bit different. But even that's pretty limited. And so, I would assume that most people view it as, fox guarding the hen house when it comes to our disclosures. But, I think like anything else, I think there's real and reasonable policy considerations to shielding certain communication, but in general, I think we need to be as open as we expect everybody else to be.
Perfect.
Is there anything you want to add on legislative transparency, or I'll take another question?
It strikes me as if we do see a House Doge Committee again in the next session, an ideal issue for the House Doge Committee to focus its efforts on is, delivering government efficiency within the legislature on responding to requests.
And I know that there's, separate from that, I know a lot of folks, the website is great, but it's 2025. So I think there's a lot of capabilities that can be brought to bear during the legislative process. Kind of substitutes a more fluid and user-friendly quick way to get information. And that's always something to aspire to. Okay, I'll take another question, and let's go all the way in the back to the right. That's a great question. So Representative Moody, this one to you, and if anyone else wants to chime in, but we're going to go right to the special session, in particular the bill that would have created a subset in a officer's file to put information that relates to unsubstantiated misconduct and shield that from transparency. And you made a good point about when you were making your affirmative remarks about kind of the dichotomy between being viewed as against law enforcement when the framing is on political terms versus trying to solve a policy issue. We want good law enforcement, but of course transparency should be at its peak at the intersection of the police power and the liberty interest. And so what can folks in the room here do to avoid falling into that trap of being cast as you're opposing law enforcement for simply demanding transparency? And if you could, because I know you're familiar with this, does it even matter that the complaints were unsubstantiated? Why does it not matter? Or if it does, maybe it does. So what can we do to not fall into that dichotomy and tell us about unsubstantiated being even relevant?
Well, and I kind of mentioned this as I talked about it earlier, unsubstantiated versus substantiated. Who's making the determination whether something's substantiated? So, I mean, part of the way I've had this conversation with those in law enforcement and publicly is, okay, these are two different categories, right, of conduct. One that leads to substantiation, one that doesn't. And so, while I may have an issue with how those two things get put in their particular piles, I thought the best starting point for someone like me, so I don't fall into this space of you just hate cops or whatever, something simplistic like that is okay, I'm going to view through your lens. And I was a prosecutor and a criminal defense lawyer. So when a witness was coming up to testify, I mean, there's law enforcement testifying in every trial from your most simple, DWI case to all the way up to cap murder, right? So we housed in our office, right? You had a list of officers that had issues and things that you had to disclose. And we always went to the, in our office, at least in the time that I worked there, we defaulted to disclosing everything. And if we couldn't, if you couldn't live with that or work through that in a cross-examination or whatever as a prosecutor, then you need to reevaluate your case. And you need to have, set those expectations for the victims as well. And those types of, those types of considerations. I mean, it's just the nature of trying a case that's going to be contested. And so, look, I get it. And so the posture I took in my discussions was, all right, I get it. If you've gone through an investigation and they have said, no, nothing's wrong here, then, maybe then I can view the world through their lens. I shouldn't be subject to being browbeat on something like that because I have gone through the process. I have had due process and I have come out the other end and I am okay. And so even though I might have an issue with that and who's making the decisions and what that looks like, I accepted that at face value. And I said, okay, I agree. If you are an officer who's rank and file and has gone through that process and is out the other end of it and nothing came of it, then I can accept that. And you're telling me that's the problem. Okay, I will accept that you're telling me that's the problem. Here's what I'd like to start. Here's what I would like to preclude from happening, right? And it's go through your list of things that you want to make sure don't go into this file, or just because we create some space to shield things because there was a broad exemption, right? It was that bill had a broad exemption from the Public Information Act. So if anything goes over there, it's gone. They can raise that exception, right? It's not subject to public disclosure. And so that's where I tried to focus my energy. I just accepted what they thought was the problem and then tried to move to the policy that I thought would create a workable scenario in the real world for those of us who want to make sure that we have proper line of sight into the relationship between the law enforcement and the community they serve. And that was the posture that that I tried to take as best I could. I think it's always viewing things through the lens of the person sitting across the table from you. Arif, I think you were in that meeting in 2019 when we started working on the anti-SLAPP stuff. It was, I don't know, 35 stakeholders at the table. I don't know if I've been in a bigger stakeholder meeting, but there were very different opinions at that table at the start of that conversation. And we got to a place where everybody felt good, I think, where we landed. And so part of it is you got to put yourself viewing things through the lens of people who are saying things that are different than you. And that's okay. It doesn't mean you're going to change your opinion, but you have to be able to have that viewpoint. And that's the posture that I've tried to take. I don't know that it's been helpful to how I've been viewed politically on these issues, but it's all I can do.
And I think that's right. I think people have to see you as persuadable in principle, not just partisan. And that's a good takeaway to have. That was a great question from Ms. Castillo at the Texas Civil Rights Project. Okay, another question. Right there, you on the left, my left. Great question. The question relates to cost estimates in the beginning. The example that was given on the panel, the $150 for 3 emails. And more broadly, is that where the line should be? What if you can't afford to pay for documents? And does that just mean you're left out of the transparency avenue? Can you address that?
I bet everybody in this audience could give a pretty good answer to this question, so I'll do my best. But it's kind of like, in my experience, cost estimates are kind of like a stew where somebody serves you stew and you're like, oh, I see chicken and carrots and maybe there's thyme in here. Like you're like, oh, I know attorney's fees. I know like if I'm requesting physical documents that they have to buy paper. But I think that a lot of times I can't tell what that cost estimate is from either side, right? I was not as much in charge of setting the cost, just telling them how much time I spent on something and trying to be as efficient and thorough as possible in a reasonable cost amount of time. But I think everybody in this room who has requested has experienced the feeling of, well, that's not how much that costs. $50 per email plus $1 to grow on does not make a ton of sense. And so I think that more transparency about what that cost is. Maybe an itemized receipt might be something that would help. What do you think?
I used one example from the city of Corpus Christi, but a month ago, I requested documents. They came back and they wanted to charge $451. So I asked them, I said, explain to me why you're estimating 12 hours for manipulation of data, 12 hours worth of redaction. What did you do to arrive at this number? And then I called the person who told me, if you request it, you're gonna get it. And I said, hey, this is what they're doing. I got an email back from them. And they're like, we are reevaluating this cost estimate. A day later, it's now $71. But they refused to explain to me how it was $451 to begin with. And the thing that the city of Corpus Christi does, and this is a tip, they use a program to search for emails. And so you have to put in data points in that program, and they're calling that manipulation of data. But the Attorney General has told them 21 times they cannot charge for that. So my tip for somebody who gets a ridiculous cost estimate is try to work with them first. And then if that doesn't work, go to the AG, file a cost complaint. City keeps losing. Guess what? Now it's 2 months later and I get my records.
Yeah, I think, the PIA is not really with the times when it comes to that. I mean, emails are not really, don't cost anything to process. I mean, you have a public information director at your city or your county. They're running the search program. How much can that really cost? So, to Rachel's point, I think absolutely work with them. In my experience, they'll usually come down after you force them to explain themselves. But I think eventually, I'd like to see, the legislature consider a statutory presumption, something right? Where records are not going to cost anything until the government agency carries a somewhat significant burden to establish that they need to charge for it.
Cost estimates could be easy barriers to throw out at people, and frankly, like, I think they're uniformly criticized because it's easy to manipulate and just be lazy and ask for a lot.
Yeah, it's one of those things, I think, to Rachel's comments earlier, where the TPIA lacks a little bit of teeth too, right? Sort of, it does pose a barrier. There's got to be a way to make sure that they're not misusing cost estimates to deny access to folks.
Even with the availability of documents, it strikes me that tacking on a cost estimate is often a deterrent. And I'd be really interested to see studies on when people just give up at that point and just walk away.
And folks on the previous panel mentioned thousands of dollar price tags, right, for information about the Hill Country floods. And, in a time where it's like, we need that information right now, the story's moving so fast, we've got to get this out to our readers, viewers, whatever, maybe you'll just try to get a grant and pay the $3,000. And we've got to remove the incentive for those unreasonable estimates.
Well, and I will also say that at the end of the day, the best course is to try to communicate, explain to these people why the information is important, but it's not always going to work. So what we often do at our station is I'll write a story and we'll have something short on air that says, we are trying to get answers. And this is what the city or TxDOT or whatever blank entity wants to charge us. We are currently fighting that. So we will tell people that has worked before, where all of a sudden the next day the city says, sorry, we're going to turn over the records.
It's always an opportunity when the government exceeds its skis, and it's good to put it out there. And it's also good sometimes to send another open records request for all documents related to the cost estimate. See what you come up with. And that's a nice tip I got from a fellow board member who's an investigative journalist. I'd love to take more questions. It's 11:33. It's time to wrap this up and head to our lunch. I want to thank Representative Moody, Rachel, Emily, and JT. You can help me give me a hand.